Hi, and thank you for joining me. I want to address the difference between the intestate share of a surviving spouse and when a spouse is disinherited through a will. So, in my last video, I mentioned the elective share of a surviving spouse, which means that if someone in their will says, I leave nothing to my wife or my husband, that surviving spouse still has a right to the elective share, which is 1/3 or $50,000, whichever is greater. So it's not so easy to disinherit a spouse in New York. Of course, with proper planning, with a prenuptial agreement, and a specific reference to waiving the elective share, it can be waived by the surviving spouse. The difference between that and having no will at all and no estate plan is that a surviving spouse in that instance, where the predeceased spouse left no will whatsoever and did not have anything to address the surviving spouse receiving the assets upon death, the surviving spouse inherits pursuant to New York's intestacy statute, which says that the surviving spouse is entitled to, if there are no children, the entire estate. So the surviving spouse is in fact the first in line to inherit. If there are children, then the intestacy statute says that the surviving spouse is entitled to $50,000 plus 1/2 of the estate of the decedent spouse, and the other half is distributed equally in equal shares to the children of the deceased spouse. So I just wanted to clarify that to our viewers. And again, if you have any questions, we are happy to answer. Feel free to call us at the law offices of Irina Yedgarova, and have a wonderful day.